offer them ownership at some point, whether it's stock, whatever the agreement is. The best way to do that, because the final event is that it become a separate corporation and operate itself and be sold at some point. The structure of moving from that one startup into the final corporation, if it's an LLC, and we bring an attorney in and share that with them as a limited partner, go right to a small business corporation, and, you know.
Yeah, I mean, every deal's going to be different, and part of that's going to be driven by who your investors are.
Right.
You know, are you taking it public? Because that's a whole different world. Are they, private investors? And what are they looking for? Are they just putting in cash? Are they bringing services to the mix? And what do they want out of it? Typically, your private equity funds are going to want stock in a corporation, and we'll jump in here. But so that's a good question. We will jump into that. Any other kind of questions you guys wanted to cover? Just make sure I hit them.
I'm sure I'll have questions.
Okay, yeah, jump in with questions as we go through.
I don't think it would be a bad idea for you to kind of run through.
Yeah, absolutely,
If it's only going to be 10 or 15 minutes or something. Isn't that what you just said, 10 or 15 minutes?
Oh, that was just the history of the corporation.
Oh, that's,
We got a long way to go.
okay, whatever. It's your show, you run it.
Alright, well, now you know me. Alright, so step one is what goes into the decision to what entity you want. And of course you could do nothing, and if it's just you, you're a sole proprietor. Obviously there are pitfalls to that. Biggest being you're exposed to all kinds of liability from the business, and the creditors can reach anything you have potentially. So we've got two considerations: one, state law, and one is tax. State law options, the corporation is probably the longest history, and that's what most people are comfortable with, and partnerships as well. But along in around 77, the first state, Wyoming, adopted the Llc Act, which mirrors a lot of the LLC statutes that were in Europe for a long time before that, and that LLC has a lot of flexibility. Florida adopted its Llc Act in 1982, but they gained a lot of popularity in the late 90s because of two things. One, the IRS adopted what we call the check-the-box regulations, which meant that LLCs now have this huge amount of flexibility to be anything they want for federal tax purposes. And in 98, the state of Florida eliminated the corporate tax on LLCs, as long as they're not taxed as a C corporation. All right. So starting with corporations. Now, you guys have you formed entities? What do you have? You have a corporation?
Yes.
Okay.
Well, that's corporation and an LLC.
And an LLC? Okay. What do
Two
you?
different
Nothing?
entities.
I'm sorry?
Two different entities.
Okay.
I also have an LLC,
Okay.
and I've helped some of our community do a couple nonprofits, which are not really big deal.
Alright, so corporation, like I said, it has the longest history. Also, a lot of formalities. You've got to file articles with the state. You've got to file an annual report every year with the state and pay the fee. And you need to have a shareholders and directors meeting at least once a year. The great thing about it is it protects you from inside creditors. And what I mean by inside creditors are those creditors of the business, of the corporation. So, corporation went out and borrowed money, corporation sold a product and there's a defect and, the purchaser is suing, those are your inside creditors. Typically, as long as you maintain the formalities, your owners of the corporation are going to be protected from those inside creditors. There's also, and I'm going to keep using inside and outside, so let me know if you forget what I meant by them. Outside creditors means the creditors of the shareholder. So can those creditors reach into the business and take that business away? Especially important if you have maybe two owners, and maybe you don't want to be subject, dealing with your partner's creditors. So outside creditors can typically foreclose on a stock and just take it, and it's theirs, they're a shareholder. Your shareholders agreement might be able to give you an opportunity to buy, if you have a partner, another shareholder, might have the option to buy that stock, but then you're dealing with a third-party creditor. The restrictions on transferability of stock only come into your governing documents. State law, If you don't have any shareholders agreement or buy-sell agreement, anybody can transfer their stock as they wish. Okay. So what's the difference between an S Corp and a C Corp? So a C corporation is subject to tax at the corporate level, and when money comes out to the shareholders, it's subject to tax again on the dividends. So you've got what we call the double level of tax. S corporation, on the other hand, everything flows through, typically, to your shareholders, so you're only paying corporate, tax at that shareholder level. To be an S corporation, there are some limitations. You can only have one class of stock. That relates to economic rights. So you can't have one shareholder getting separate allocations or higher dividends than the other. It's got to be based on your ownership. And that doesn't mean you can't have different voting rights. So you could have one 50% shareholder who has all the voting rights. And that could come in when your investors start coming in. Maybe they don't want control, or you don't want them to have control, but they still get their cut of the end of the day profits. The shareholders have to be individuals. They have to be either U.S. citizens or resident aliens. There are some limited entities that can own stock in this corporation. That would be certain trusts, electing small business trust, or a qualified subchapter S trust, or a grantor trust that, for tax purposes, effectively treated as the individual who created it. Those rules can be kind of tricky, so you want to make sure you get some tax advice before setting those up. And an LLC that has one member and is disregarded for tax purposes can also own S corporation stock. Okay. So why would you choose a corporation? C Corp, double level of taxation. It's not great. Most people don't want it. Your corporations, are they C or S?
Yes.
Yes, okay.
Is it a big challenge to as you grow, to change it from a C to an S?
You can change from a C to an S. The timing on that has to be right. You've got a little window each year when you can make the election. When you do it, what happens is the IRS takes a snapshot as of the date of the conversion, and all of that sort of built-in gain that you've got, and sort of tax that hasn't been distributed, and a lot of other complicated tax rules are still going to be subject to C Corp tax down the road. Let's say you own a piece of real property in there. Don't recommend it, but let's say you own a piece of real property in a C Corp and you convert it to S, and it's appreciated by $500,000. When you sell it, depending on when you sell it, you're going to pay corporate level tax on that appreciation as of the conversion date. But that doesn't mean it's, there's some time limits on that, so if you can take it out long enough, there might be some benefits to it. But the C Corp might be good if you're planning to go public on a short time frame, and you're okay with dealing with that double level of taxation early on. And early on, you probably have a lot of expenses, not as much income, so the double level of taxation might kind of wash out anyhow. Also, if you're going to have more than 100 shareholders or investors who are coming in that aren't qualified to own S stock. The 100 shareholder rule, family members within a certain degree of relation are all treated as one shareholder. So you could have 200 family members if you got a really big family. Fringe benefits sometimes are not deductible in an S Corp context, depending on how you're paying them. That's typically not an overriding factor, but I just wanted to mention it, that if that was a big important factor in your business structure, it's something that you need to think about. S corporation limits double taxation, but reduce FICA taxes. So if you're an operating entity and you've got income coming in, you've got other employees who are providing services, you can pay yourself a reasonable salary for acting as CEO or whatever else you're doing, and take the rest of the profits out as distributions. You'll only pay employment taxes on the part of the salary, and the rest can come out just as distributions offset against your basis, so potentially entirely tax-free. That can save you quite a bit of money, at least 2.9% on the Medicare side. So, COD, income tax planning, I'm hoping that's not a big issue for you guys at this stage, but especially when, 2008, when everybody was having problems and, getting bank loans forgiven. When that loan is forgiven, you've got cancellation of debt, and you pay taxes But if the debt was the S corporation's debt, and the S corporation at the time of the forgiveness was insolvent or going into bankruptcy, it doesn't flow through to the shareholders. So in a partnership context, that would not be the same, and you would have COD income as a partner. Okay. Planning to go public again would be a problem. You'd have to convert from an S back to a C, most likely. All right, general partnership. There's no formality for the general partnership. Mark and I decide to start a business. I've just created a general partnership. Typically would recommend having some form of partnership agreement, and especially if you're going to get into complicated tax allocations, you're going to want to cover that in a written document. And how do you escape? That's something else you probably want to cover in a partnership agreement. You have to have at least 2 partners to create the partnership. That's an error on my slide. It cannot have unlimited duration. Once one partner's gone, your partnership is done, you dissolve. There's also, if the business ceases to operate, you would terminate. There's also some deemed dissolution rules under the tax code that, more than a 50% partner leaves, you're deemed to have dissolved the partnership and started a new partnership with the remaining partners, basically. Okay. General partnership, there is basically no protection. General partners are jointly and severally liable for all of the debts of the business. Outside creditors may have some limitations, but not really. Typically, the creditor can foreclose on the general partner's interest, and now you've got a new partner that you don't know and don't want to deal with. The interest can be transferred, but it's an assignee, so they don't have management rights, but in a general partnership, it's not great. Okay, limited partnerships. This is your general partnership. You file a certificate of limited partnership with the state. That's the formality that you got to go through. Again, partnership agreement not required, but certainly strongly recommended. In this context, your general partner, you have to have at least one, will be responsible for 100% of the debts, liabilities, but the limited partners will have limited liability. I jumped ahead. Outside creditors, very similar. They can't foreclose on the limited partnership interest, so you've got some protection in charging orders, which I'm going to talk about in the LLC context as well. But charging order basically says, I stand here, I have an order, I'm your creditor. I can have a right to anything that comes out of the partnership from you, but I can't vote your partnership interest, I don't have a say in the management, I just have to stand here and wait. It actually gives you a really good bargaining tool with your creditors if you're the partner, because no creditor wants to stand there and hold something where they're potentially not going to get any money out of it, but they're getting potentially tax allocations and paying taxes on their share of that partnership interest. Again, transferability of interest really can't transfer, at least as to the management rights, they're just an assignee. Okay. You've got the flexibility in terms of the taxes because you're only paying tax on the partner's share at the partner level, but the partnership rules are kind of complicated in terms of just state law. I'm not personally a fan of the partnership statutes. We aren't really seeing them a lot anymore, thanks to the rise of the LLC and the flexibility it gives. But when we do see them these days, it's usually in the context of some estate planning, which I'm not going to get too much into, but they do give you the flexibility and liability protection to some extent. Okay. Limited liability companies, which are the most popular these days because they give you that flexibility I mentioned. You have to file your articles of organization with the state, file your annual report every year. You don't have to have an operating agreement. You can default and use the Llc Act's rules to govern your entity. But I would strongly recommend the operating agreement, especially if you have multiple members, to deal with how things are going to be allocated, how decisions are going to be made, and how you get out if there's a problem. The liability of the members. So inside creditors, as long as you maintain those formalities, don't commingle your personal stuff with the business, you should be protected as a member from the debts of the LLC. Obviously that doesn't include where you personally guarantee something. Outside creditors. In a multi-member LLC, they are limited to that charging order I mentioned. So the creditor just stands there waiting for distributions to be made, which may never be made. Single member, a couple of years ago we had a case decided by the Florida Supreme Court, Olmstead, and actually on the 11th District Court of Appeals, that basically said in a single member LLC, the creditor could take the LLC interest and take the business. The new Llc Act, which went into effect in January 2015, sort of adopted that. It's got a little bit of a patch, and maybe you could be limited to a charging order. I don't think it's going to give you great protection. So if you're a single member LLC, odds are your creditors are going to be able to take your business. So it's just something to think about. Maybe you want to bring in a spouse or a friend who you really, really trust to be that multi-member if you've got creditor concerns. The interests are not transferable like the partnership. So if I transfer my membership interest without the consent of my other members, that transferee is just standing there waiting for distributions to be made, has no right to vote the interest, no right in management. Your operating agreement can overcome a lot of these things if you want to allow interests to be transferable, for example, or you want to provide a mechanism to allow the transfer, or to certain people, you can do that. There are some non-waivable provisions in the LLC. Yeah, go
Does
ahead.
Homestead only apply to Florida? This
Yes.
is an internal Florida.
Yeah, it's a Florida case. It was decided by the 11th DCA, but it dealt with bankruptcy, and frankly, it was some bad facts and fraudulent type stuff. But okay, so here's the flexibility I mentioned. What can an LLC be for tax purposes? If it's single member, it can be a disregarded entity, meaning you report everything on the member's return, Schedule C if it's an individual. It can elect to be a C corporation. It can elect to be an S corporation, provided that member is an eligible S shareholder. If it's multi-member, it defaults to a partnership for tax purposes. It can elect to be a C, and if those members are eligible S shareholders, it can elect to be S. Was there a question? The agreement, you have a lot of flexibility in terms of dealing with management, voting, how things are going to be decided. If you're in the partnership context, you can deal with allocations differently. Just because you own 50% doesn't necessarily mean you get 50% of everything. You can kind of segregate things if you want to. Like I mentioned, there are some non-waivable provisions dealing with duties of members and managers to the other, duties of loyalty, duties of care. You can't really waive. You can limit but not waive. Things like that. Liability protection, again, we talked about. So that was fast. What questions do we have?
One more time for clarification on the LLC. If it's a single member LLC, it can be treated or subject to creditors.
So if I start a
Exceeding
business,
the assets, or
yeah, so let's say let's just do an easy one. I own a piece of real property and I put it in a single member LLC.
right.
And I go out today and I get run over somebody in the street and they sue me. They get a judgment. They can reach my membership interest in that LLC and therefore take that property.
However, if you had multiple.
Right, if we owned it together, they could get a charging order against my interest, but they couldn't come in and make decisions on
What's a
how
charging order?
So it's an order from the court. It's like a lien. So
Okay.
it happens with partnership interests and LLC interests. It's, the creditors has this little order that says, I get any distributions that come out of this LLC or partnership to this partner who owes me money.
So it's a lien against future sales or distribution?
Future distributions, but he has no right to force the distributions. So you could, if you've got friendly people involved, we think, well, we're just gonna compile a whole bunch of, we're just gonna build money up in the LLC until your creditor goes away. We'll pay ourselves salary while you deal with him, but in the meantime, we'll let the distributions build up.
And typically that's not solved if they do that by negotiating a new.
Yeah, it
You
gives you some
discount
bargaining
from the
power.
charging orders results, correct?
Yeah, typically you're gonna see some sort of
You want your
bargaining.
money now, then we'll give you X dollars.
Yeah, they don't wanna sit there and wait.
No negotiate. And can you bequeath it, or is the charging order still in effect?
So once a charging order is, now you're getting into sort of fraudulent transfers.
Well, if you've done it,
Which-
you're doing it.
And I should clarify, fraudulent transfers, I'm referring to the Uniform Fraudulent Transfer Act, which Florida has adopted and is actually looking at amending with some potential risks, but I don't want to get into that. It doesn't mean it's fraud. It just means you're transferring assets away from creditors who are known or expected. So I know I owe this person I ran down in the street $1 million. I'm gonna transfer everything to my husband. Well, that doesn't work.
Right. What about death?
On death, so they would still be creditors of the estate, if
Okay.
it was part of the
So
estate.
fall
they're-
back to your normal.
Yeah.
Okay.
So if you're making it as a gift, if you sold for, full value,
Mhm.
that should be okay, but then again, they would be trying to get that cash.
And also, if you're a single member LLC, you're saying the taxes can be treated without declaration. If you are C, you could still fall through as an S to your
Wait, say
personal.
that again?
I thought I heard earlier when you were an LLC, you said you're a single member LLC.
Okay,
Now, when it comes to taxes, tax purposes, you can either, even if you are C, you can still.
yeah, so if you're an LLC and you're a single member,
Right.
if you do nothing, you're a disregarded entity.
Which means you can treat your taxes in any.
Which means everything flows through to, so if you own it, it's gonna all get reported on your Form 1040.
Yeah, personal, like an S.
Yeah, but you can file an election with the IRS to be a C corporation, or you can file an election with the IRS to be an S corporation. And then once that election's made.
So LLC flows into the tax forms. S is on K1, is that correct?
Yes.
Yeah. So LLC flows into what on forms?
So an LLC that's disregarded, it's gonna get
Like a
reported
single
on
one, yeah.
Schedule C if you're an
Just Schedule C,
individual,
yeah.
or, the appropriate schedule.
Just like if you're a sole proprietor.
Yeah, exactly.
Yeah.
So, yeah, and then if it's a partnership, it would be a 1065 form, and the K1 would get issued to the partners. If it's an S and 1120S, and again, K1.
So if you are in an early stage startup, so you don't have yet revenues, and you may have a partner, but you may just trying to get a couple of co-owners, what form would you suggest to start with?
LLC is going to give you the greatest flexibility, and you can always convert an LLC to a corporation if for some reason you have an investor coming in and they don't want to deal with the fact that their LLC interest isn't transferable. They want a corporation, they know they can transfer the stock, and that's what they want. And a lot of times they do. So you can do that. The tax changes, so disregarded entity to anything is going to be pretty easy because it's just like forming a brand new corporation or partnership or whatever you're doing. Once you get operational and trying to go, basically anytime you're dealing with a corporate form, it gets tricky. If you're forming a new corporation, for example, C or S, if you're putting all the money in, you've got an operational business and there's some gains potentially or liability that you might get relieved of when you put it in there, depending on how much you're gonna own and what the other guy is putting in, it could trigger some taxable gain or income to you. It's complicated and it's probably a little too complicated to go into right now, but that's why choosing the best form up front is.
And it's not an issue to issue some ownership to co-founders who come in later than
Yeah, again, so the partnership level
Uh-huh.
concept, that gives you a huge amount of flexibility, because let's say you've got someone who's gonna provide services and you don't have the capital to pay them. You could give them a partnership interest as a profits interest, so they don't have to pay taxes on the value of their interest as of day one, because as of day one, their interest has zero, no profit. But as it expands, they get the profits out and it comes out allocated to them as partnership income without that immediate tax consequence when you give it to them. Conversely, let's say you had an S corporation and you had a service provider and you were going to give them some interest. That's taxable income to them based on the value of the stock. So let's say you had $1 million company, may not have that much in available cash, but the value is $1 million and you give somebody 5%. Now they've got, what is that, 5,000? I just
50.
lost the ability to do math, thank you, 50,000. I'm a math person, I swear.
Good higher math, this is just basic arithmetic.
So that $50,000 is taxable income to them. So if they were an employee, they now have to pay ordinary income taxes, employment taxes on $50,000 they didn't actually get in hand. And sometimes that's a deterrent to your.
It's like winning something on The Price is Right. You
Yes.
get a gift from a corporation, you have tax on it. I don't know if they actually pay for people's taxes on those though, because you're right. When The Price is Right, you win your $50,000 trip. Do they pay the taxes on it or not? That's interesting.
Typically, they don't offer you an option to take the cash value, which is usually
Because
less than the
you
real
get the trip,
value.
then you might not be able to pay the taxes for the trip.
And an LLC, if for example, you create two entities for whatever reasons, an LLC and a C corporation, can those two merge?
You can merge, depending on what your end result is going to be, you might have some tax consequences. Typically, you could take advantage of the reorganization rules under the tax code for C and S corporations. And as long as ownership isn't changing and cash isn't going to different people and you meet all of those technical rules, you should be able to merge. The LLC and the C Corp, for state law purposes, you can merge them, and that's,
And then
That's the easy part.
the end merging entity will be what? Can be LLC or C?
it could be LLC or a corporation. You're probably gonna wanna end up staying as a corporation, because if you ended up as a disregarded entity or a partnership, it's gonna be as if you took your corporation, you dissolved it, you distributed everything out, you recognized gain on everything that had appreciated and all
Double
the,
taxation.
yeah, exactly.
So you wanna end up to be a C corporation?
Yeah.
I'm sorry about that.
So, for someone who's gonna not get into the large scale capital markets, like large corporations, I'm not quite sure of the advantages of the C Corp. For
There,
most people who are not into like thing businesses, if you're into service businesses, don't really see the advantage to the C Corps at all.
I agree with you,
Yeah.
unless you're planning to go public or,
But even if you
Go
planning, for most people in the startup phase, they're looking to sell to someone who'll take it, or, and they're not even looking for private equity, they're looking for angel investors, things like that, and that's like way down the road, so. The other, I guess, so you're looking at LLC or S.
yeah, and so, in
Yeah.
your context in the S Corp versus the LLC or, as disregarded or partnership, one advantage there, if it is a service, like I said, in the S Corp context, you can pay yourself your salary and take the rest out as distributions and save on some employment taxes.
Right.
If you're in a partnership or disregarded entity, 100% of what you're getting allocated, whether or not it's even distributed to you, is subject to self-employment taxes.
That's the big advantage of the S Corp.
Yeah.
And so what, in terms of the relative distributions of salary versus sort of level of profit or gain, so to speak, what is the guidelines for apportionment, shall we say?
Well, the IRS says you pay yourself a reasonable salary or they're gonna come in and yell.
Reasonable, yes.
And then it's a question of what's reasonable.
Right.
Typically you would look, okay, well, if I were working for somebody else, what would I get paid? What are other similar businesses paying people in the same position? That's what, and I know there's stuff out there that gives guidelines on these kinds of things, but.
Well, CEO can get 50,000 and 500,000. Between those two, it's all over the place.
You know, I can give you sort of the extreme example of, okay, I'm a doctor and I own my practice and I'm the only one in there practicing. I'm paying myself $10,000 and taking the other $1 million out in distributions. Not a reasonable salary.
Well, there's a-
Because 100% of the income is from my personal services. So, you know, you might be able to pay yourself something less than that $1 million, but
there's no business entity profit concept.
what do you mean by
Well,
that?
it's so closely held, in other words, you are the whole business, right?
Yeah, yeah.
Right.
I mean, you've still got your liability protections and everything else, but using a doctor is probably not the best example.
If the dividends paid out were greater than the salary paid out, would that in most cases be considered unreasonable in the eyes of the IRS?
I don't think that's gonna automatically be deemed unreasonable. It's really gonna depend on what your business is. You know, what are you paying yourself, what are you paying your other employees? If you're paying yourself, like the $10,000 in my example, and you're paying your nurse $100,000, your salary is probably unreasonable. But if you're commensurate, you're the CEO and you're making more than every other employee, that's probably a good gauge. I will say a good accountant can usually tell you what they think is, what they're comfortable with putting on their return as salary. If they look at you like, I'm not signing your return, then you got a problem.
Idea.
in structuring a startup that you are going to eventually sell off to invest to people who want to buy them. And you want a group of investors, not necessarily for money, but for services. So you set up an LLC and you say, okay, I need an attorney, here's so much of the LLC, here's an accountant, here's a whatever. With a agreement in the structure of that, when you sign on, that it's for the development of that entity, and that at a certain point, you're going to convert to a C corporation for the event of selling that to a larger company that's going to come in and buy you, and that's where you get your payout at that point based on how much you own of that group. Tax-wise, you've not taken any money out of the LLC. You won't actually get paid until the sale is made. And your biggest asset is intellectual property of development of that program.
Yeah, I'd have to walk through the numbers on that one, but what happens there, so you had a partnership. It's as if you liquidated the partnership, everybody took their cut, and recontributed it to the new C corporation. And so, are the people who are putting it in, do they need the 80% control test to avoid gain recognition on what they're putting in? Depending on how much debt you had in there, you might have triggered gain recognition on the coming out of the partnership. So you really kind of have to go through the specifics of what it looks like at that stage. You can do it, but it may not be as beneficial as starting out as a C corporation.
So is the 80% rule, does that mean that the people that are coming into the C corporation have to control 80+%, or otherwise they are going to have a liability?
Right, at the time you're forming it, you're putting in cash that whoever's putting in the money have to have at least 80% of the stock.
And then afterwards, if they start to sell
And then
the stock
if
off,
down the road you want to put more, if somebody else wants to come in and put more some sort of property or something in, they need to have the 80% control based on who's coming in. So that's when down the road, as you bring in more shareholders, it's the potential for triggering some gain recognition to the contributing shareholder.
Anything else? Okay, then thank you much.
Yeah.
Great.